Yo, Yamamo, Aqua Bastranko, so eba POG Media, so Mr. Safi no aba, ube subscribe na wa like Jumedi no, Ediame obitimin so Ashi Jumedi no, na afofro and so and sa akabian, please click on the notification bell no so sanebea. Yet any news be out to platform no so I won't so won't no dear air call any dear air by yanko yensum na yemfa and some do donano and ye the umbrella and the Supreme Court a ruling a 5-2 against the NDC side just say no and the Supreme Court to say the afenyo markings at the bar court no backbone engine to say NPP majority just say ruling no aba upon away and NDC lawyers be led by lawyer Tamakulu judgment by or didn't be atuja or ka hon some person court near kokuti in chimu and then this dissatisfaction just say a or the idea or the abba the ruling Supreme Court no a ruling no it reveal in Zimbabwe chese Gigi Akuffo Addo so na ebedru ba no Ghana yen judicial system na ebe pro there atete o kan se bebre e chance mu yen koni konkoti.
So the Supreme Court has ruled. There's a 5-2 in favor of Afenyo. I'm told that Justices Stanko and Lovelace dissented.
It's close.
Yes.
Okay.
I love to read dissent.
Yes.
And because you raise the issue of dissent, Randy, I just want to read a very classic dissenting view by Justice Lord Atkins in the famous case of Liversidge versus Addison. And this is what Justice or Lord Atkin had to say.
It's an interesting case. Read it.
It's a very interesting. It's a groundbreaking. You know.
He was a liberal.
And that is what he said.
Yeah.
I view with apprehension the attitude of judges who, on a mere question of construction, when faced with claims involving the liberty of the subject, show themselves more executive-minded than the executive. They show themselves more executive-minded than even the executive. You see, Randy, we are building a constitutional democracy. A democracy that we are hopeful and confident will live.
So interestingly, the panel had the original 5.
So the original 5,
the 5
I think all went well on the injunction.
Sat on the injunction. Yeah. And then the other 2.
They stay.
They stay. So the other 2, the 2 were Justices Stanko and
so they dissented.
Lovelace. Yeah. So the 2 were added were those who dissented. The 5 who ruled in favor of the stay, all ruled for Afenyo.
But let's not read things to it. I mean, we are just reading too much.
Oh, right.
It's quite possible.
I have just made an announcement.
I know, but let me say, okay, I want to stop us from reading. But
no, the 5 that were, I don't want to say unanimous 5.
Okay.
The 5 that were unanimous in their decision on the stay.
Stay.
Yes, I mean, were unanimous. They were unanimous on their view on this. Yes. The 2 that were added,
but as you know,
dissented.
Interim judgments are easier to obtain than substantive ones.
Okay.
You just have to show where the balance of convenience lies, isn't it? That's the test.
Randy, I think now that there is a judgment, we can fairly critique it.
Okay.
So I'll proceed.
But you question the reasoning.
No. Hold on.
You are going to speculate.
Hold on.
Okay.
You see,
it lasted like half a minute.
Oh, okay.
No, they're just reading the verdict.
Yeah.
Once they decide, then...
I think usually such ones, they'll go to conference and have conference.
Yes.
So usually you won't even get a judgment now, immediately. It may take maybe a week or a few days to get it. But you see, I was on the Mo Ibrahim conversation when you introduced the breaking news. You see, when I first saw the Mo Ibrahim report on Ghana, first of all, it's a very credible platform, devoid of the NPP NDC conversation. So when I saw it, I was apprehensive because for a long time, if you monitor the Afrobarometer report on the workings of the courts, the reasoning and what Ghanaians have generally said about the court had always provided a cause for concern. For me, the height of it was when the National Security Minister, the Honorable Kandapar, a person who had had considerable working experience with Ghanaian institutions, had cause to tell the courts or the judges in their face that when a particular consistent outcome is churned by the court, it has the potential of undermining one critical thing that is required in a democracy, public confidence. In fact, Randy, the only way you and I will have a dispute and would approach the court is that we believe at the end of the day we will abide by the outcome. But the very moment our confidence in the system of adjudication is compromised or undermined in any way, the next will be that we'll be resorting to self-help. And that self-help mechanism is a recipe for chaos. When I saw this Mo Ibrahim report, in fact, I even said, there should be an emergency judicial council meeting, at least to consider this urgent matter. Because you see, it goes to the very core of justice delivery. When an international organization, and remember, business people, when they want to invest in Ghana, what they do is to look out for such polls, to look out for such views from credible institutions. Now, if you're a business person and you are coming into the country, and you read from Mo Ibrahim or his report that the impartiality of the judicial system had moved from a record high by not a 1 percentage point, not 10 percentage point, not 20 percentage point, but 30 percentage point from 2017 to date, that should be worrying for everybody. In fact, if you practice from our court, if you're a judge and you are not worried by the Mo Ibrahim Index, its report on Ghana, then there is a problem. For us as lawyers, because we represent foreign clients, when they come, they'll ask you, do this due diligence for me, do A, B, C, D. If they are coming with a perception that our court is less, when it comes to partiality, it goes to the very core. And it even undermines inflow of investment. Because for a foreign investor, there's always a potential that you may have an issue.
In fact, even some of the recent cases at international arbitration,
yes,
that have traveled through our courts, even fortifies this position. The rulings of our courts on some of these cases that eventually ended up at arbitration, and the results from arbitration even fortifies and reinforces this point that you are making.
Randy, so like I'm making the point to you, if you have an investor and he wants to come and invest in this country, and he has any occasion to examine this report, question that we need to be asking is, how confident will that investor have in approaching any of our courts? That, for me, should be a great concern for all practitioners. It has nothing to do with NPP, NDC. My learned friend tried introducing that, it is because the NDC appears to talk down on the court system, and that is what has influenced the Mo Ibrahim Index. With the greatest respect, I mean, these international organizations appreciate the internal political dynamics. And so they appreciate what is called a bias in coming out with these indexes. If the conversation is only about NDC, they may think that, this is politics. But they have been speaking to investors. And those investors, what is the level of confidence that they have in how we adjudicate matters, especially matters involving the government? Randy, I'll give you a classic example. If you recall, there is this company called Imperial Heritage.
Yes.
Imperial Heritage, a business people, they have obtained a judgment from a court. Now listen, this is a judgment that was obtained when evidence was taken. Evidence was taken. And the judge, after everything, evaluated the evidence and on merit ruled against the Republic. If the Republic has any misgiving, you appeal it. In a very extraordinary and novel manner, the Attorney General filed an application to set aside the judgment. One, that the filing fee or whatever that was paid did not commensurate with the claims, and some other issues. And the judge agreed. And on the basis of an application, set aside the judgment that he did upon review of the evidence. I mean, when you do things like this, you will get an outcome. But you will be sending a different message across. Randy, so I am worried. Look, when H.E. John Dramani Mahama presented the election petition in 2020 to the court, one, when the defense was filed, the NPP,
Yo nyamisha so ahwe dwumadie no ebesi esemre ofam yunu ena ye de airbrow no but unya subscribe like dwumadie no share nema afoforo enso ensa enka please click on the notification bell no so send be ya ye de any news be to platform no so a won so won hu de airco ene de airba na insam no etwagu ensam no etwagu and lawyer ayetamakulu etwaso issue and dissatisfaction a chese wonya ewo eye the court ni mu a chese ehun sensem de say bubuja yenko ne ko gento aso.
Their first ground was that the petition should be dismissed because it discloses no cause of action. That was refused. So already the court acknowledged that the writ disclosed a cause of action. So you cannot sit here and say John Mahama presented something to court that was, if not, don't put, when your people ask that the matter be dismissed because it did not disclose a cause of action, the court would have dismissed it. The mere fact that the court agreed and adjudicated evidence was taken is that the court found that there was the basis for coming to court. I have always maintained that we lost a glorious opportunity in refusing or disallowing the Electoral Commission chairperson to testify. Election adjudication is not a mere contractual rate that you come to court with. It is at the core of mandates. It's at the core of people's ability to determine through the ballot board who leads them. But we treated it as the usual contract, and A, B, C, D, and Madame will not, and this is, and it ended it. People are watching. And always remember that the people who are watching are equally sane and intelligent and are picking this. You see, where the impression is being created that anything that makes Akuffo comfortable, the court will either delay it. That thing is fueling a very dangerous perception out there. That Akuffo must be made to feel comfortable, pampered. It's a perception that is dangerous. And you see, Randy, why do I make this point? Immediately, MPs passed the LGBTQ law, the bill. The Constitution provides the mechanism if the president strongly feels that there are constitutional issues, the mode that he must go. That was ignored. And we saw the cease and desist letter from Mr. Bedietuo. If you recall, The president started raising issues about the bill when he met the diplomat at the time when there was no injunction application from Richard Delasky. How did the president know that Richard Delasky was going to go to court the next day? Because at the time when Mr. Akuffo was speaking to the diplomats, there was no injunction application. How did he know? Was he the one who sponsored Richard Delasky to go to court?
Richard is not an NPP, by the way. I know him very well. He's a good friend. And I did my post call with him.
Okay.
In fact, he opposes NPP quite a lot.
Okay.
So I know Richard for sure.
I didn't say he's an NPP.
No,
I said
I'm just trying to
sponsor.
say that he's not.
No, sponsorship is different.
Well, I read.
That's why I choose
Yes.
my word carefully.
Yes.
I am saying that when Mr. Akuffo met the diplomats,
Yes.
was there any injunction when he was talking to the diplomats?
I don't know the.
How did you know that the next day Richard Delasky was going to court for an injunction? Was he briefed by someone? So you see, you people should not have the inclination that the people you are in the arena with, excuse my language, adapt. We see what is going on, and we appreciate what is going on.
You are not like me.
But you see, Randy, my friend, and again, look, Dom Levo. At the time the court eventually determined the matter, it had become Pyrrhic victory for Dom Levo. When citizens of the Republic, at the end of this kind of justice, it fueled the Mo Ibrahim report.
Okay.
Because you see, look at the speed, the alacrity with which this Afenyo market matter had been determined. The same speed relative to Dom Levo. Look at when the president came out with the Imposition of Restriction Act, one of the EIs, and my own professor of international law, Professor Tia, went to the court to challenge the constitutionality of those EIs, among other things. By the time the court gave its verdict,
Too late.
there was nothing useful to do with that verdict.
Yeah.
Now, so when these things happen consistently, and the impression is created that Akuffo is being pampered, that anything that makes him uncomfortable is either kept on the banner. How do you expect Dom Levo? How do you expect that plaintiff to feel? Is there a different set of laws for Afenyo marking? When there is a different set of laws for other citizens of the Republic, it's painful. And that is why I have always maintained that we all do have collective responsibility in making the court system work. Now, on this vast issue, this morning, my learned friend took us into...
Makojobuafu says that with all you said about the judiciary and the Mo Ibrahim Index, you won your case in High Court in secondary yesterday. What do you say about that?
No, hold on. Let me. You see, what he had not said, whoever, Makojobuafu, sorry, what he had not denied is all the instances I've given. Was it the case that when Dom Levo approached...
No, he's not...
No, I'm coming there.
That
I'll respond to him.
Yes.
When Dom Levo went to the court, what happened? When the president was challenged on the EI, what happened? Are they not are they in doubt?
E-levy, the MPs.
E-levy.
I mean,
All those matters.
The Supreme Court says that they're asking the GRA to keep records, proper records.
You see,
so that if tomorrow the case overturned, GRA will be able to calculate all E-levy I've paid and return them back to me.
The person who sent this text would want to gaslight us and make us feel we are rather the problem and not where the problem is coming from.
I'm sure the point he wants to make is that it's all not...
But that is why. No, hold on. But even the Mo Ibrahim, it didn't say it's 100% drop.
Yes.
I think it's 68.
It said it's 30. So
No,
you
it
can't.
said 30. I think
No, the drop.
from moving 8.
The drop from 100
drop.
down.
Okay.
Yeah.
The drop is the 30 percentage point.
No, it was 8 or something, and then it dropped to 68 or so.
No, 50 now. 50.
Oh, I thought
So the percentage point is, if you read the entire. So I am even interested in a situation where I can adequately advise a client.
You're not making your points?
And be clear on it.
Okay.
You see, Randy, on this Article 97,
Yes.
thankfully, when my brother was making his submission, he had a beautiful constitution by him. Randy, if you go to Article 97, just by the side of 97, these are the words: tenure of the office of members. Tenure. How is it futuristic? Look, the Constitution, Article 97(1), has just by rate.
I think it will be better with
hold on.
judgment.
Hold on.
They said the reasons will be out tomorrow.
Yes.
So
I
you
think
listen.
yes.
No, I beg you. Tenure of office of members.
Yes.
How is tenure futuristic?
Yes. I think I will.
But you see, even more. No. I mean, you made some point, and I need to strengthen it. You see, conveniently, when you were reading F and G, and where the G says, if he leaves the party of which he was a member at the time of his election, to join another party. To join another party. Randy, you know what happened?
Yeah.
If you recall, in 1979, Victor Usu's party got Kwekuba and J.H. Usu-Achampong elected as members of parliament on Victor Usu's party. Now, when these two came to parliament, for some interesting reasons, they left Victor Usu's party and now said they are on their own. So they said, no, if you're on your own, you came on the ticket of Victor Usu's party, so leave. Then they said no. So they stayed until the 81 coup. So when we're making the...
So you can see he was seeking to remain there.
They stayed.
They're seeking to remain
No,
there.
I'm coming. So when we're doing the 1992 Constitution, and like we say, the Constitution mirrors our history.
Okay.
So when they were the framers were putting the 92 Constitution together, mindful of what happened...
Can we have opportunity to talk on the decision before we leave?
Yo, nyame chance wa hwedwumadie no ebesi sesemre onka ho na onkyere wa hyem na onye wo kese na dwumadie no ekoso ya no mesre say anase dwumadie no esin mesre say on subscribe like dwumadie no share na ma foforo enso ensa nkabia please click on the notification bell so send be ya the news be to platform no so a wonso wo hunu de eko ene de ba na de da ekoso ya no pitire ha ene de nsem no ebesi na yeni eguso edi eyesa Supreme Court nsensem ye chi de any just bia ebebrem nti stay tuned makram